Understanding PREA, Sexual Assault Rights for Survivors in New York. Attorney Andrew M. Stengel. The Prison Rape Elimination Act, or PREA, was enacted in 2003 to address the epidemic of sexual assault in American correctional facilities. PREA sets mandatory standards for prevention, detection, reporting, and response. Every New York jail and prison that receives federal funding must comply. That means that every incarcerated person in New York has PREA, sexual assault rights. The most common locations of prison sexual assault occur at women-only prisons: Albion Correctional Facility, Bedford Hills Correctional Facility, and Taconic Correctional Facility. But men are also targets and victims of sexual assault in New York State's other prisons. PREA does not create a private right of action, meaning you cannot sue directly under PREA. However, PREA violations are powerful evidence in civil rights claims. A New York prison sexual assault lawyer will assert your PREA sexual assault rights and use PREA compliance failures to strengthen your case. What PREA requires of New York correctional facilities. PREA requires facilities to conduct annual audits and submit compliance data to federal authorities. Staff must be trained to recognize signs of sexual assault and report incidents immediately. Facilities must provide confidential reporting channels for survivors. New York City Department of Correction Facilities and DOCCS, New York State prisons, are both subject to PREA standards. The standards cover staff conduct, physical plant requirements, investigation protocols, and survivor support services. Retaliation against a survivor for reporting sexual assault is explicitly prohibited under PREA. Facilities must have policies against retaliation and must monitor for it. When retaliation occurs, it compounds the underlying civil rights violation. When New York facilities violate PREA standards, common PREA violations in New York facilities include failure to separate known aggressors from vulnerable populations, inadequate camera coverage in high-risk areas, and failure to complete required investigations within mandated timelines. When a survivor reports sexual assault and the facility fails to investigate, that failure violates PREA standards and may also violate the survivor's constitutional rights. Deliberate indifference to a reported assault is independently actionable. Audit records showing that a facility repeatedly failed PREA compliance reviews are significant in civil litigation. They establish an institutional pattern rather than an isolated incident. That pattern supports claims for municipal or agency liability. PREA, sexual assault rights in civil litigation. PREA. Audit results and investigation records are obtainable through freedom of information, law requests, and legal discovery. An attorney familiar with corrections litigation knows where to look and how to obtain records quickly. Staff training records can show whether officers received the required PREA education. If training was never provided or was inadequate, that failure supports claims of supervisory liability. Supervisors who ignored known risks face personal liability alongside institutional claims. The law firm of Andrew M. Stengel, PC, uses PREA records strategically in every prison sexual assault case. The firm understands how compliance failures translate into legal liability. Enforcement through civil rights litigation. A civil rights lawsuit under Section 1983 is the primary vehicle for enforcing constitutional rights after prison sexual assault in New York. The lawsuit can name individual officers, supervisors, and in some cases, the municipality or state agency. Survivors who succeed in civil rights litigation can recover compensatory damages, and courts may also award attorney fees under federal civil rights law. This fee-shifting provision makes it possible for survivors to access experienced representation without upfront costs. Speak to a New York prison sexual abuse lawyer now about your PREA sexual assault rights. Schedule a consultation with the law firm of Andrew M. Stengel, PC, by emailing info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.